from Mr. Muleya. Thank you so much for making the time to join us on the stage tonight.
Thank you very much. It's my pleasure to be here at Diamond TV.
The Commission has been bestowed the responsibility to provide oversight on matters relating to access to information. Are you able to break down this oversight that has been bestowed on you as a Commission?
Thank you very much. As you know, the Access to Information Act was assented to on 22nd December 2023, and it came into effect in June 2024 when there was a commencement order that was issued by the Minister of Information as required by Section 1 of the Act. Now, the Human Rights Commission has been designated with the role of providing. First place, I should start by saying that this Act is implemented on some general principles. The first one is that information should be proactively disclosed to the public, and that information holders should provide that information expeditiously and inexpensively, that it should not be delayed in terms of giving that information when it's requested, and it should not be too costly for someone to access that information. But also that this act should be interpreted and applied on the basis of presumption of disclosure, that you do not need to be, information holders do not need to be requested for information. On their own volition, on their own will, they should make that information public. It's a principle in transparency, because we are trying to promote transparency. That it's a principle in transparency that the starting point is openness. And any issues regarding secrecy must be justified by, for instance, public interest. If the public interest overrides the special interests that are requested, or there is a specific legal restriction that exempts that information from being disclosed. But ordinarily, the information should be readily available to the members of the public so that they can access public services, they can participate in governance of the country from an informed point of view, they can hold the leaders accountable, and also that the decisions that are being made by the authorities must be known by those who are going to be affected by those decisions, whether decisions or actions. So it's a very important tool in terms of promoting good governance, transparency, accountability, and improved service delivery.
Before we can get into the details of what this means for the Zambian person, listening to you, it makes me, you're painting a picture that you are the police, that ensures that, the access to information is enacted, or is followed, or is implemented, if you like. But several years in your existence as the Human Rights Commission, you've been described by so many as a weak institution, as a toothless, bulldog, if you like. And so, how then will this work out with an institution that is already perceived to be weak?
Thank you very much for that information. That is the historical information people knew about the Human Rights Commission. And I should state that one of the landmark development that has taken place in the human rights protection space has been the strengthening of the powers of the Human Rights Commission in 2024. As you may be aware, the Human Rights Commission Act number 39 of 1996 was repealed and replaced by the Human Rights Commission Act number 4 of 2024. Now, this act, unlike in the past, has strengthened the powers of the Human Rights Commission. One of the powers that have been strengthened or granted to the Human Rights Commission is that it can now take legal action against anyone who has violated human rights, or on behalf of a complainant of human rights. We can now conduct public interest litigation in the courts of law in order to secure redress. That power was not there. We were only, as a commission, empowered to make recommendations, which could either be accepted or rejected. But now, there are real powers to do that. Secondly, we have powers of search and entry. If we believe that in an institution or a premise, there are human rights violations taking place, or there are likely to be human rights violation, or there is information that will be relevant to our investigation, which is being kept in that institution, we can get a search warrant and enter that premise to get a record of anything that will assist in our investigation.
So you said these powers were bestowed on you when?
2024.
2024. Have you been able to exercise some of these powers?
We have been able to exercise these powers. We have, in the recent past, petitioned the state, for instance, on a number of cases relating to over-detention. We have, issued the habeas corpus to ensure that those who were detained beyond the prescribed period of time are taken to court, and they start attending court hearing. And it's working. And all these cases we have taken so far, 9, we have been successful as Human Rights Commission against the state.
Against the state.
Yes. So we have real powers. And I want to say that even in terms of implementing the access to information, the Act clearly says that the Commission can either use its powers under the Constitution, under the Human Rights Commission Act, under access to information, or any other written law. So our powers under the Access to Information Act go beyond what is prescribed under this Act. So we have broad-based powers to ensure that access to information is guaranteed as a right, because it is a fundamental right. Now, you asked, are you a police? We have different layers of providing oversight. One of them is to provide capacity building to various stakeholders. We have regulatory powers. Regulatory powers to regulate information holders. And the way we do regulate is by issuing guidelines, which we issued under Gazette Notice 1624 on 5th December 2025. So we've issued guidelines to guide information holders on how they should comply with the Act. So that is a regulatory power. Then we have got oversight law. Oversight law, the Commission has powers to review the decision of information holders. If information holders do not grant access to information, requesters have a right to appeal to the Human Rights Commission. And I should underline that the Human Rights Commission oversight law comes in play at an appeal stage. We are not an institution of first instance. The requesters, they should go to information holders. And when that information is not granted, or is deemed to have not been granted, or there is dilator or delay in providing that information, then they can appeal to the Human Rights Commission to intervene. Now, under that, these powers of the Human Rights Commission are not superficial. They will make legally binding decisions or orders to information holder, depending on the outcome. And the decision of the Human Rights Commission can only be challenged through the High Court. Someone has a right to appeal against the decision of the Human Rights Commission to the High Court if they are not satisfied with the decision of the Human Rights Commission.
Obviously, Mr. Muleya, when this act is fully tested by the people, obviously your officers are going to be overwhelmed. I would like to find out the capacity that you have as the Commission to be able to handle these appeals, because you need to be present across the country. Exactly. What is the current situation at the moment in terms of your capacity?
Yes, that's a real issue, and we are alive to that. And even the government, when they bestowed this mandate to the Human Rights Commission, they were alive to this. Currently, the Human Rights Commission has a head office in Lusaka, and we have got physical offices in all the provincial centers in the provinces where we have got officers. But in addition to that, because of the added mandate of the access to information, the government last year gave us a treasury authority to engage an initial number of 16 additional members of staff.
From how many?
No, for the just we had in total we are at that time about 75 or so, but we were an additional number of 16 who were specifically, employed to provide this oversight. So, in addition to the existing members of the public, we know that this is a quasi-judicial function. As we said, you are saying it's a toothless, but it's no longer a toothless institution. It has quasi-judicial functions like a court, same court, making legally binding decisions. So what we did was now to restructure the commission, that instead of having the investigations and the legal department, which was combined, we separated the investigations to be alone, and we established a fully fledged legal compliance and the legal department. So we have a number of lawyers because there were a lot of issues relating to the enforcement of the decisions of the Human Rights Commission. And that's why we are saying the issue of being a toothless institution is no longer existing, because we have got our own lawyers. Now we are no longer relying on the Attorney General's chambers. Previously, we were relying, like any other public service institution, on the Attorney General's chambers to prosecute or to follow up certain cases. At the moment, we have got now direct local standard as a Human Rights Commission to sue in the courts of law using our own lawyers.
For many people, when they hear the access to information, what comes to their mind is the media. The TV stations, the newspapers, and all these media institutions. It's not about the people themselves. Maybe let's break down this. Is the access to information only for the media?
No. The access to information is an empowering tool for the citizens or anyone who stays in this country who want to access information, either for exercising their right or for the provision of services. For instance, members of the public may want to know, for instance, how the Constitutional Development Fund is designed. What are the procedures? What are the guidelines? How much money has been allocated? Who are the actual beneficiaries? What contracts have been, granted under that fund? Who are the contractors? It provides that you have to, information holders should provide the details of the contractor, the amount given, and all those specifications, because they have a right to know how the public money, for instance, is being used. So it's not necessarily for the media alone. Individuals who want information relating to public service provision have a right to seek that information. But we are saying that this access to information should not replace the existing mechanism for accessing that information. Because using the access to information, there's a prescribed manner and form. You use Form 1, which is under the regulation, where you have to access that information. And within that 7 days, you should be given that information. But there should be other means. People should, information holders should not wait for information that should be in the public domain to be requested. In fact, Section 8 of the Act provides that all information holders, and information holders are all those public institutions and all those parastatals or any institution that utilizes public fund. You may be a public body, but you have a contract with the government. You are utilizing public fund by virtue of your business transaction and so forth. So you are an information holder. You are under an obligation to proactively disclose that information. So under that section, that information holder should proactively publish the structure of the institutions, the mandate, the functions, the provisions, the services they are providing, how to access those provisions, and all these mechanisms, regulations in place, the policies, so that people, when they want to have access to information, they know how to access that information. And in the event that there is an omission in terms of provision of those services, they should know the mechanism that they can use within that institution to seek redress. So that issue should not be an issue that people should be requesting for information, which should ordinarily be available to the public.
In this interview, you've consistently mentioned information holders. Perhaps let's get to that. What does the Act define as an information holder?
Information holder, they're saying any public institution, or parastatal, or any institution that utilizes public funds, or any institution that may be in possession of information that is of significant public interest. So you may not be a government ministry, for instance, or department, or spending agents, or a parastatal. You may be a private body, but you may be have a relationship in terms of funding from the government, or you may be holding information that may be of significant interest to the public. For instance, Diamond may have information, people may be wanting to have that information in their own investigations, to seek redress for a right. Because
even on Diamond TV is a private entity.
Yes, you can, if you're in possession of information that is of significant public interest. In fact, the 4 principles of this act is that any institution that may assist in the provision of information which is relevant to the exercise or protection of any right, you're an information holder, you should be able to give that information to the public. And that information should be deemed public. You don't need to be requested for that information. So digitally on your website, there should be adequate information about who you are as an institution, what is your editorial policy, and what do you stand for, all those things. What departments do you have, sections, so that people would know that, if I want marketing, it is marketing, they are the right. All that adequate information should be proactively disclosed to the public.
Let's put things into context. I earlier asked you about who could access this information, and you said it's for every Zambian.
Every Zambian or anyone with a resident permit in Zambia can seek this public information. So
one who is watching from Mutendere and has been wanting to access CDF, are you telling them tonight that they could go to the Constituency Development Office and request that they are availed with information on how CDF is being dispersed or how their name was left out when they applied?
Definitely. They can go there. They go to Ward Development Committee. They need to know the structures, who is dealing what. At lower level, there's Ward Development Committees. They work with other structures. Before they even go to the constituents, they should know where they applied to. They have the right to that information. In fact, the Act says the decisions or acts of information holders should be disclosed to information requesters. The reasons for making a decision or taking an action should be known to those people who are impacted by that decision or action. So if you are left out, you should be informed as to why it's not possible for you to access that.
I think the context that I asked that question in was, how do I even reach? Is there a form that I have to submit? Do I need to buy something?
The form, as I said, under the regulation, there is Form 1, which you fill up.
So this Form 1 is in all institutions?
We are sending them there. Even you can download it from HRC website. You can get it from the regulations which have been published. It was published on the 29th August through Statutory Instrument number 56 of 2025 by Minister of Information. It's readily available, but also that what we are saying is that this act is should be interpreted and applied on a basis of presumption of disclosure. People should not be filling up this form in order to get that information. Ordinarily, that information should be readily available to the beneficiaries. Now, that is the area now, various stakeholders, civil society organizations, the media, the Human Rights Commission, we have now to, we have a mammoth task of sensitizing information holders, that information that of that sort should be readily available to the public. They don't need to start spending time going to request for that information. There should be reports readily available and in accessible format. And if there is information that doesn't require to be disclosed, that should be treated separately. But ordinarily, all information is deemed to be public. So breaking the culture of secrecy, Mr. Mansa, also will be another mammoth task. Yes, this act may not be a magic bullet. Yeah, it cannot be a magic bullet because we have done comparative studies in the region. We have countries like South Africa, which acted the Promotion of Access to Information Law in 2000. Okay, that's about 25 years ago. And the implementation started in 2001. So you find, generally in the public institution or in private institution, the culture of secrecy, confidentiality is embedded.
It's embedded.
So you need to now start demolishing that to promote a culture of transparency, openness, sometimes even information which is not supposed to be hidden from people. You even hide the information which is meant for the same people you're hiding from. So that's what we're talking about now. The implementation to require a lot of sensitization, understanding, a change of institutional attitude, but also in terms of management of information, how they store information, they manage information, and I should come to that effect that all information holders, that's why they are required by law to appoint or designate information officers. These are the people who should help information requesters to access that information.
This act or this law was signed by President Hakainde Hichilema on 22nd December 2023 and officially came into operation on 25th June 2024.
Yeah.
Does this then mean that from as far back as 2024, people could actually access information?
If they tried to do that, but the issue there was for now to allow information holder to start putting their information in order, to start to proactively publish information either on their website or any digital platforms, but also to put any systems, internal mechanisms within their own institutions. But also it was a period of institutionalizing, the operationalization of the act itself. It had to ensure that there are enabling legislation that it had to be put in place. As I said, it was enacted, assented to on 2nd December 2023. Before coming into effect, it had to come into effect on 25th June 2024 when the commencement order was signed through statutory instrument, which was issued by the Minister of Information as required. From there, the Information Ministry needed to develop and issue regulations, which they did. They issued regulations on 29th August 2025. So these regulations are the ones which are accompanying the forms. So those are processes which are being done. And the Human Rights Commission under Section 38 was required to issue guidelines And to issue guidelines, we had to wait for the regulation to be issued so that the two documents are speaking to each other. So on 5th December 2025, through Gazette Notice 1624, the Human Rights Commission published the guidelines in the government gazette. So all these, then the judiciary are supposed now to issue the rules as required by Section 39 of the Act. So there are these processes, legislative and institutional, that are taking place before fully fledged implementation of the Act. That's why there was this progressive compliance period of 2 years up to 25th June 2026. Even then, you'll find that certain institutions may not have systems in place where you can walk in an institution that we want this information. It's readily available. So that's why now the Human Rights Commission will continuously be issuing directives and notices for compliance to information holders to ensure that there is a continuous compliance to the Act as required.
So the grace period has been given until the 25th of June 2026, is that so?
Yes, according to Section 41 of the Act.
So
but the reality may mean that it may not even, there could be still, as I'm saying, some teething problems which you can't resolve all these issues which I'm talking about in all these
but
institutions.
in principle, by the 25th of June, all public holders or information holders must have created systems to...
Systems in place, and that's when now, because there are administrative penalties which are supposed to impose for failure to
about to come to that. And so when the grace period ends in June, it therefore means that all public institutions are ready to give out information. Let's talk about, and before we can get to the penalties, let's talk about, the issue of you accessing information and whether you need to give reason for why you need that information. Because sometimes you might ask for sensitive information, just come to Diamond TV and say, I need this footage. Probably will ask you, why do you need it for? Does the Act provide that the person requesting for information must provide, reasonable grounds to why they need that information?
No. The Act is very clear. The requester doesn't need to give reasons for requesting that information. And that's one of the general principles that information, that every person has a right to access information. That's the first general principle. You have a right to access information. And the second one is that this information is deemed to be public. There should be that proactive disclosure of that information. It's not up to the requester to justify. The reason for denying, not granting that information, or the burden of explaining, justifying, lies on the information holder. If that information, for instance, is exempted under Part 4 of the Constitution, the Act, because there's certain information which is exempted from disclosure. So the information holder, when they refuse to grant that information, they should give reasons for refusing. Themselves, they are obliged to give reasons if they are refusing. And they should cite the specific law that they are relying on for denying you that access to that information. So Part 4 provides areas where information may be denied in terms of national security, the right to privacy. So that information is exempted. Or there's a specific legal provision that exempts that information from public disclosure. That now it will be justifiable, but the requester doesn't need to give reasons for wanting that information. It should be given as a matter of right.
That's interesting to note. Under what circumstances can the information holder refuse to grant information to this person who is requesting. Are there any, reasons for why that information can't be granted?
Yes, there are some reasons that may, warrant a lack of access to that information. The right to access information, like any other right, is not absolute. There are prescribed limitations, or what we call drawbacks or derogations, that when there is, it relates to national security, public order, public health, public morality, public safety. Those are general restriction to every right, and you find that under section, under Article 19 of the International Covenant on Civil and Political Rights, the UN 1966 Convention. It provides that special access to information, because the right to freedom of information, all these access to information, they are emanating from the right to freedom of opinion and expression, as enshrined in the International Covenant on Civil and Political Rights, which is Article 19 of that convention. So there are limitations. It's not an absolute right. So if the information you're asking is endangering national security or national defense, it may not be granted. If the information you're asking, it violates the right to privacy, it may not be granted. If the information you're asking is undermining, for instance, commercial or financial viability of a certain institution, that when they started disclosing those trade secrets, it would disadvantage them in terms of being competitive in a business. That information also is not granted. You can ask for a contract. They will be given this and that and that. But as in terms of the details of maybe marketing, the strategy you want to use, that cannot be given.
Who determines whether that information is confidential or could pose a threat to national security?
There are written various pieces of legislation which provide or prohibit that kind of information. And it's very clear there are also jurisprudence in terms of the decisions that may have been made elsewhere. For instance, you can ask information if you want to do for certain information to do with law enforcement. You can ask about, well, how far have you gone with the investigation? What are you doing in this and that and that? But you cannot ask what tactics are you using? Are you planting informers? Or what other gadgets are you using? All those details, and you cannot, that information cannot be given to you because it may, undermine efforts to prevent a commission of a crime or to get to conclusive investigations that would redress any violation that could have happened. So there are exemptions that are well prescribed by law, and they are, they meet international standards. So those restrictions, they must be prescribed, they must be justifiable, they must be reasonable and necessary in a democratic society.
And the one that is providing that justification is the information holder. And
yes, they will cite that law, whichever law. Yes, that's what it's just not from their own will and so forth. They're saying they'll give reasons and cite the law. That's what the Act says. Cite the law or the provision of the Act or law that prohibits them from disclosing that information. Mind you, it is also a penalty for disclosing information that is not supposed to be disclosed.
We'll come to penalties a little bit later on. Let's talk about the time frame that the Act provides to be given, before information is given to the requester. How long must I wait before the information holder gives me the information?
Thank you very much. Ideally, they're saying within 7 days. It could be within 30 minutes, 1 hour, 2 hours, but they're saying within 7 days.
This is 7 days or 7 working days? 7
working days.
It means we exclude the Saturday and Sunday.
Yeah, what we've done, because the Act may not have been clear, in the guidelines we have clarified so that there is no misinterpretation that we say 7 working days. so that that information should be given within that period. But if, for instance, you receive that information and you want to refer to another institution which you think is better placed to provide that information, that transfer should be made within 5 days of receiving that request. And then the information holder has received that referral must, within 7 days of receiving that, write now to the requester, acknowledging that they've received this request. It means now the requester now will start dealing with that information holder. But if after the expire of 7 days there's no response, it's deemed to have been not granted. The information will have been deemed not to have been granted, or that the information holder has refused to grant that. So at that point...
Before we get to that point, and so I come to Human Rights Commission, or I go to HRC requesting for information. I find this officer that is designated to handle me, that handle that information. So within the 7 days, am I supposed to be going back to HRC to check if my response has come, or perhaps I'll need to be called? What exactly is
you need to be communicated with, because it's really written. They have an obligation to provide that information to you, and if they think that the information you are looking for is too difficult to find within that period of time, there's a provision within the law to extend that request for not more than 14 days. Okay? That is provided for under the law. If they think that because of any circumstances not be possible for them to provide that information within 7 days, the Act allows the extension of time to grant that access to information for not more than 14 days. But the requester, if you are not satisfied with that extension, you think this is just a delaying tactic, you can also appeal to the Human Rights Commission. That's what the law provides under that Act. So there are different circumstances.
So you are saying that if at the end of the 7 days you're not communicated back to, it means that the information is not granted. Then you can begin your process of appeal.
Exactly. See, the information is deemed to have not been granted. So they failed to grant access to that information. If they have not requested for that extension, or they have not communicated, they have not referred that matter to another institution. But there are also instances where that information is, they are not referring it to an information holder. They are referring to, they want to find out from a third party whether that information should be granted. So on that one, they will request to extend the period to 21 days instead of 7 days. So within 21 days, they should get back to you. The third party should get back to the information holder, either granting consent to release that information, or denying to grant that consent, or may not respond to that request. And then if at the lapse of 21 days, none of those things happen, the information is deemed to have not been granted.
So, and then I have the right to appeal to the Human Rights Commission.
Yes.
So then when I appeal to the Commission, how do you take it up from there?
The Human Rights Commission, when you appeal to the Human Rights Commission, there are also forms from the rules. The rules, as I said, the judiciary is working on the rules. So it will be based on the rules and the forms to appeal to the Human Rights Commission. You are supposed to get with the documentation of that Form 1 which you had requested, to get that information, and the response from the information holder, or whatever lack of action that could have happened, because it's an appeal.
Yes.
So we need to review the decision. So to review the decision, we must have adequate documentation from the information holders, from yourself, because as an information requester, when you lodge a request, you are supposed to be given a certified copy of that request, so that you also have that information other than the one you leave with the information holder. So that at every time we have got a documentation. When they respond to you, that's why whether they are agreeing to give you information or they are denying you to give you information, that should be written. It's not just verbally. Information holders are supposed to write.
I was even about to ask that if you, in what format is information? In what format must information be given?
Exactly,
to you?
and there are various forms where you may request the information. It can be written. Sometimes, depending on the format in which the information is available. That's why there's a requirement that all information holders must store information in accessible, reproducible formats. Yes. You may want to have a photocopy of a document if you want. They say, okay, we'll photocopy. You want a record of something, a video, it can be given. You want to have a scanned document, you can be given. You want the images of the video news, for instance, to be transcribed, described, because you are dealing with a visually impaired person and is not seeing that. So you can transcribe. They at an expensively, a minimum fee. When you look at the schedule of the regulations, there are schedules of fees. Yeah, photocopying, I think 3/4 75.
Oh, you pay for that?
Yes, 3/4 75 in way. If it's scanning and sending information which is already in the computer, you're just sending it, there's no amount that should be given. So you agree on for what format you want that information. Yeah, if you want a video to be transcribed, and that's why it becomes a bit of maybe expensive. You find maybe 75 kwacha and so forth. But any record with that which is maybe 50 megabytes or below is a 50 kwacha.
Let's talk about the powers that now were granted, to you for information holders that deny giving the information. What powers will you exercise on them?
We order that information be released, and as I said, the Commission has broad powers under this law. We may not just restrict ourselves to the access to information. Of course, we make order, legally binding order, and there are penalties for refusing. Okay, administrative penalties for each day that the failure occurs to provide that information. So every day they will be charged, every day will be charged. Those are penalties. But also there are other sanctions, which are of criminal nature. For instance, someone is looking for information, then you destroy that information in order to conceal. Oh, they are looking for this information, just you want to destroy. That now becomes a serious crime. That means now the police gets involved, and we work together as the institutions that are enforcing the access to information to ensure that sanctions are meted out against the information holder who does that, or any information holder who obstructs the Human Rights Commission in the exercise of its duty. I've said that under the Act we have powers of search and entry. So, but we don't expect that it should reach that stage. But we can exercise that power now direct as a Human Rights Commission to investigate and get that information using those powers. Under those powers, you can get a record, a photocopy, or anything that will assist in our investigations. Those powers are granted to us as a Human Rights Commission under the Human Rights Commission Act. And we are allowed under the Access to Information Act to either invoke the constitutional powers or the Human Rights Commission Act or any other written law in Zambia that relates to access to information. So those are the powers.
Can you be arrested by virtue of refusing to grant information to the requester?
No, unless you commit a criminal offense like destroying information, obstructing, for instance, the Human Rights Commission from it doing its work, it becomes a criminal offense. So there are those sanctions that apply, which are of criminal nature. But refusal is an administrative issue, so there are administrative penalties that are imposed on an information holder. Yeah.
Mr. Muleya, Human Rights Commission spokesperson, thank you so much for making the time to appear on this day tonight.
It's been my pleasure. Thank you. Good evening.